Hello, my name is Addison Caruso. I'm an Ohio staff attorney with Shake Environmental Legal Services. And this is some general information that you should know before you sign a contract to lease your Pore or storage space for carbon capture and storage. A little bit about Shake Environmental Legal Services. We are a nonprofit law firm that represents clients of all income levels on environmental and energy justice matters. We are dedicated to the idea of community and client-centric representation and believe in empowering the communities and individuals we work with. We provide services on a pro bono and sliding scale to individuals and organizations, and we aim to focus on traditionally underserved clients who are directly affected by environmental harms. We have many wonderful non-attorneys on our staff as well who provide support, resources, and assistance to communities and assist them in building people power. We also have a robust internship program where we aim to educate young attorneys and law students to understand how best to serve underserved communities. As a disclaimer, this presentation is designed for general informational purposes only, and the information contained in this presentation should not be construed to be legal advice or to signify the formation of a lawyer-client relationship. If you have any questions following this, you should reach out to an attorney to clarify or seek representation if needed. What is pore space? Pore space is the empty space between particles of sand and sediment, or the space between and within rocks. When carbon capture and storage, when CO2 is injected into the ground, it fills these spaces. Oftentimes, pore space is left behind when a fracking company has extracted oil or gas from an underground mineral deposit. Who owns the pore space? The pore space, generally there are two rules of who owns the pore space. There's the American rule and the English rule. The American rule is in the majority, and most states follow it. Generally, it means the surface owner or the landowner, and not the mineral owner or the fracking company, owns the rights to this pore space after the minerals have been extracted underground. Some states that appear to follow the American rule are Montana, Oklahoma, Louisiana, New York, West Virginia, New Mexico, and California. The reason they appear to follow this rule is that not all states have passed statutes or have definitive case law on the matter. The English rule, in contrast, is in a minority of states, and that means generally the mineral owner or the fracking company possesses the right to the pore space after the oil or gas has been extracted. Texas and Kentucky appear to follow the English rule. Generally, Ohio, Pennsylvania, and West Virginia have been identified as possible spaces for carbon capture and storage because there's a lot of pore space in this area. This is because a lot of the area has already been fracked, and after the oils and gas have been extracted from underground, it leaves spaces for carbon to be theoretically stored underground in the area. Ultimately, despite what the law says, if you contract for something else, that generally controls. So you should always read the contract and see exactly what you're agreeing to. If you have any questions, please get in touch with us at our general number, or you can visit our website or contact us at our email for more information. Thank you.